Thank you for your patience. We just finished votes and we walked down here as fast as we could. My name is Colin. I'm the Member of Parliament from Okanagan, Shuswap, British Columbia, and I will be hosting this fourth annual Parliamentary Forum on Religious Freedom. I was first elected in 2006, and I can still recall sitting in my seat for the first time in the House of Commons. And I was overcome with a sense of trust that was put into me by the constituents to protect the freedom and provide good government. And I bowed my head and I gave thanks to all those that had gone before me that had provided Canada with law and order and had committed themselves to protect the freedom of the citizens of Canada, which has been the center of our Canadian heritage. This evening we will look at one freedom of many that we have in Canada, but I would argue it is one of the most important freedoms, the freedom of religious expression. We will do a performance review of Canada's record on protecting the freedom of religion in Canada. Tonight, Greg Dockstetter will be our moderator for the discussion. We'll introduce the great presenters that we'll have on the subject tonight. I'm sure you're going to be challenged. It will be interesting to hear how we are doing in Canada. I think we all feel comfortable with the fact that we can express our religious freedom in this country, and yet there's some subtle things that have happened in the past little while that have maybe challenged some of those opportunities and challenged us to look at, are we going to have to defend those rights that we have in this country. So, Greg, would you come forward and Greg will be our moderator for tonight, and thank you again for being here.
Well, my name is Craig Dockstetter. I work for David Anderson, Member of Parliament. We have, as you can see from your agenda, we have an hour of presentations. We're going to try to put them into 15 minutes each, or just under 15 minutes. We have a lot of material to cover tonight, and so I'm going to start by apologizing for the fact that we are going to try to cram a lot of information into a very short period of time. Our speakers have been very gracious to take what could take books to explain and try to get it into under 15 minutes. And so we really appreciate you understanding that this is really, we're covering a lot of ground in a very short period of time, but we thought it'd be a good introduction to religious freedom in Canada. What's the history? Where are we? What are some key components of that? And we're really looking forward to hearing from all of our speakers tonight. I want to introduce our first speaker, Dr. Jim Wallace. And I am not going to read through the bios for the sake of time. You will find them here, but we are very happy to have Dr. Wallace with us tonight. Join me in welcoming him. Thank you. It's a delight to be with you this evening. On the drive north from Seattle to Vancouver on Highway 5, travelers encounter at the border crossing an imposing, beautiful monument, the Peace Arch. It was dedicated in 1921 to commemorate the end of the War of 1812. Two inscriptions are engraved at the top of the white stone arch. First, children of a common mother. And second, brethren dwelling together in unity. Now, all of us who have siblings understand that children of the same parents can be very different. And yes, sometimes siblings struggle to get along. And yet, even as children are different, parents can also be poles apart. I have two parents, one by birth and one by adoption. For you see, I was born in the United States, but lived and worked much of my life in Canada. I was adopted as a Canadian when I proudly stood in front of a judge in Calgary and swore my allegiance to the Queen and to Canada. my two parents, the U.S. and Canada, are singular and special, and I love them both very much. They each have strengths and weaknesses, and over time I have come to deeply value each one of their virtues and, yes, their quirks. This difference is very obvious when it comes to the subject of religion and politics, two often conflicting disciplines that have been my life's work. America was established with the idea of separation of church and state, and clearly entrenched in the First Amendment to the U.S. Constitution. This metaphor and model has become the dominant popular image of religious-state relations, particularly in Western societies. However, in Canada, there is no one model of religion and state. There are, I believe, in reality, four models, two historic and two emergent. Although plainly evident and operative in Canadian society, few Canadians, beyond perhaps a few cloistered academics, would be able to explain these different religio-political constructs. The four religion-state models that I would suggest to you in Canada are, number one, the official state church. Number two, laïcité. Number three, separation of church and state. And number four, total secularity. I'm going to briefly explain each one of these ideas and then draw some conclusions at the end of how they impact Canadian society today. The first model is the historical model of official state religion or official state church. State religion dates back to ancient times when kings and rulers were often considered to be gods, or at the very least, high priests overseeing the religious rituals of the state. State religion has evolved over time, with some states broadly sanctioning particular religions, while others go so far as to have an official state church. Now, when the French and British came to explore and colonize the New World, they came with strong state church traditions. Indeed, Jacques Cartier claimed the Gaspé for the King of France in 1534 by planting a 30-foot wooden cross crowned with the King's coat of arms. Not long after, priests and missionaries followed to claim the new territory for their God and their country, and to convert the indigenous peoples to their brand of European Christianity. Thus, for over 200 years in Canada, Upper Canada was dominated by the religion, laws, and culture of the Church of England, even as Lower Canada was likewise controlled by the Roman Catholic Church. State religion was so dominant in early Canadian life that the Treaty of Paris, which solidified British control over Canada, granted to, quote, Roman Catholic subjects, quote, the freedom to practice religion, quote, as far as the laws of Great Britain permit, end quote, which of course meant under the control of the Church of England. Subsequently, in the Quebec Act of 1774, the Roman Catholic Church was granted broad quasi-state governmental powers in Quebec, but again, quote, under the King's supremacy, end quote. For hundreds of years, our country was divided along state church lines, with religion often acting as a proxy for other issues that have divided us, like language, law, school systems, and culture. Even during the Northwest Rebellion led by Louis Riel, the two dominant religious communities split over what to do with the Métis leader and how to resolve the long-simmering complaints of the indigenous peoples. In the early 1900s, a new type of state church emerged, the United Church of Canada. Born out of the modernist fundamentalist controversies, the United Church embodied prevailing Canadian values like peace, cooperation, tolerance, and unity. Although not officially a state church like the early Anglican or Catholic churches, the United Church was truly national in scope, influence, and favor with both elites and common people alike. For much of the 20th century, the United Church was Canada's de facto state church. as it actively engaged in influencing political, social, economic, and even foreign policy issues. For many religious Canadians, there still remains a deep subconscious allegiance to the idea of an official state church, be it national or regional. Whether it's Catholics in Quebec, Anglicans in Ontario, Baptists in the Maritimes, Mennonites in the Prairies, or the United Church in BC, these affinities shape not only religious ideals and practices, but also social and political convictions, which ultimately influence votes. The second historical religion-state model is that of laïcité, or the French idea of secularism. Laïcité is a much-debated concept that emerged in France in the 18th and 19th centuries as the state struggled to free itself from the overriding influence of the Catholic Church on French society. The essence of the struggle was not the prohibition of religion, but rather the restriction and the control of religion, as well as the differentiation between public and private social spaces. In 1905, French law officially declared that the Republic was laïque, secular, as it sought to end the regime of recognized religions begun under Napoleon. Churches were demoted to the private sphere from their privileged status as state institutions. Their subsidies were removed, and the equality of all religions was guaranteed. Further, the 1905 law prevented public servants from, quote, signifying their own religion, end quote. For over 100 years, the meaning and application of laïcité has been much debated in France. In 2004, the Stasi Commission recommended that the principle of laïcité be extended to ban, quote, the wearing in public schools, colleges, or secondary schools of signs or garments that display religious affiliation, end quote. This became popularly known as the French headscarf law. In Canada, the ideals of laïcité gained prominence in Quebec in the 1960s as the Quiet Revolution sought to free the province from the stifling alliance between the government and the Catholic Church. The principles of laïcité began to be taught in schools, incorporated into government policy, and debated in public life. Laïcité in Quebec has evolved over time to be a more open and less restrictive form than its French antecedent. However, the debate still rages over the shape and scope of secularism in Quebec. Consider, for example, the contrast between the 2008 Bouchard-Taylor Report on Reasonable Accommodation and the 2013 introduction of the Quebec Charter of Values. The meaning of laïcité in Quebec, and by extension, Canadian society, is far from settled. The third model of religion-state relations in Canada is the emergent American model of separation of church and state. It is based on the First Amendment to the U.S. Constitution, which declares that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, end quote. Contrary to popular opinion, even in America, the words separation of church and state do not appear anywhere in any of the American founding documents. Rather, the concept was introduced by President Thomas Jefferson in 1802 in a letter to the Danbury Baptist Association in Connecticut. Then, a century and a half later, in 1947, U.S. Supreme Court Justice Hugo Black quoted Jefferson in his majority opinion in Everson v. Board of Education, declaring that, quote, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. By including this concept in a Supreme Court majority opinion, separation of church and state was thus granted the force of American law. Separation of church and state is a popular metaphor for religion-state relations that is widely adopted in many Western liberal democracies, including Canada. Moreover, in Canada, the pervasiveness and influence of American culture and media has resulted in this metaphor being embraced by many Canadians as their preferred expression of religion-state relations. Many Canadians erroneously believe that separation of church and state is guaranteed in the Canadian Constitution, when, in fact, Canada constitutionally accommodates religion in ways that would never be accepted in the United States. The fourth model of religion-state relations in Canada is an increasingly emergent model of total secularity. Many Canadians hold no religious beliefs, and of them, an increasing number prefer that the state should be totally secular and devoid of any religious accommodation. According to the 1991 Canadian National Census, 12% of Canadians claimed no religion as their religious identity. 20 years later, in 2011, that designation had doubled to 24%, or a quarter of Canadians claiming no religion. The rise of the nuns, that is the N-O-N-E-S, not the N-U-N-S, is being studied and debated by leading academics and demographers in Canada and the United States, for this phenomenon is seen in both countries, but more so in Canada. There appears to be a correlation between increasing secularity and expanding urbanization, as well as generational differences. According to University of Lethbridge sociologist for religion, Dr. Reginald Bibby, the preference for no religion does not indicate a decline and disappearance of religion, but rather the polarization of religion. For at the same time, some religious identities are declining in Canada, others are significantly increasing, primarily as a result of immigration from the global south. It is ironic that at the same time some are calling for no religious accommodation by Canadian and provincial governments, total secularity, others are calling for more religious accommodation. In conclusion, when I look at the relationship between religion and state in Canada, I see four competing models, not one dominant design. The official state church, laïcité, separation of church and state, and total secularity. This complexity is the byproduct of Canadian history, Canadian demography, Canadian culture, and yes, Canadian political accommodations. But the most significant reason that Canada's religion-state model is ambiguous is that not enough time has passed for the Constitution to be interpreted by the Supreme Court of Canada. For ultimately, religion-state relations and models of accommodation in Western liberal democracies are not determined by constitutional fiat, but rather by judicial interpretation. In the United States, the First Amendment to the U.S. Constitution was adopted in 1789. But it was not until 1947, 158 years later, that the model of separation of church and state began to fully take shape through the ruling of the U.S. Supreme Court. Indeed, the majority of U.S. Supreme Court cases regarding religion in American life have arisen from the 1940s to the present. In Canada, we have only had 32 years for the Supreme Court to rule on the Charter of Rights and Freedoms and thereby create the superstructure for religion in Canada. With each Supreme Court case, with each opinion interpreting the meaning of freedom of religion in Canada, the relationship between religion and state becomes more settled. Perhaps in the coming years, a landmark ruling by the Supreme Court of Canada on religion-state relations will create a single metaphor, that all-encompassing archetype that embodies the fullness of Canadian values in the same way that Justice Hugo Black did for the United States back in 1947. Perhaps the resolution of the Quebec constitutional question will bring renewed clarity about who we are as two peoples in regards to religion. Perhaps Canada will proudly maintain its multiplicity of religion-state models even as we pride ourselves in our multicultural mosaic. Perhaps, who knows? Whatever the result, Canada will be different from the United States. Canada will continue to be a world role model for religious freedom, and Canada will be a refuge for people of many faiths and people of no faith for generations to come. Thank you.
Thank you, Dr. Wallace. I warned you, I packed a lot in here. Our next presenter is Dr. Janet F. Buckingham. Dr. Buckingham, many of you probably know, and she is very qualified to speak on what she's going to speak to us about today, which is a legal and political history of religious freedom in Canada. Join me in welcoming Dr. Buckingham.
Freedom has always been highly contentious in Canada, but of late there seem to be a multiplicity of issues that are in the newspaper on a fairly daily basis. Canada has always been a place where religion is highly contested. I recently published a book called Fighting Over God. I'm not here to advertise that, but to summarize it. But I wrote it with a motivation of letting people know what the history of religious conflict is and the hard-fought battles that there have been for religious freedom in this country. In addressing religious conflict in Canada, I address 3 eras. So we had the models, now we're going to deal with the eras. Now, eras are time periods. The first era is Roman Catholic Protestant conflict. The second is exclusion of religious minorities, with a focus on competition between Roman Catholics and Protestants. There was very little room for Jews, Sikhs, and Hindus. The third era of religious conflict is the current one, and that is the relationship between secularism and religion, or religions. In the early days of Canada, religious conflict was mainly between Roman Catholics, the French, and Protestants, the English. There was deep suspicion bordering on hatred between the two. Roman Catholics had been guaranteed the right to maintain their religion after the Plains of Abraham. As French government leadership was forced to leave, clergy took their place in leading the Quebecois people and maintaining their culture. This conflict played itself out in many ways, the best known of which was the Manitoba schools crisis. But the crisis in Manitoba spilled over to that new province from events in Quebec and Ontario. Quebec passed a bill settling the Jesuits' estates and engaged to assist, this was horrifying, of course, to Protestants, and offended the rabidly anti-Catholic Orangemen Association. Orangeville in Ontario is not named such because there are orchards nearby, not because it was a hotbed of Orangemen. When they failed in getting changes to Catholic education in Ontario, they turned their sights on Manitoba. The ensuing political and religious conflict took years to resolve and determined that Western Canada would be Anglophone and Protestant. But this was not the only conflict. The Orangeman Order's major celebration, the 12th of July, was a public holiday in all but Maine, in Ontario and particularly in Toronto, and was often a source of rioting with the Roman Catholic Young Greens. The Pope declared 1875 a Jubilee year and encouraged pilgrimages. When the Archbishop of Toronto announced pilgrimages, they led to rioting as Orange Order members blocked the pilgrims. These are 2 examples of how conflict played itself out between Protestants and Roman Catholics. In addition, the education system was what historian O.D. Skelton refers to as the arena where religious gladiators displayed their powers, an occasion for stirring the religious convictions and religious prejudices of thousands, and of demonstrating how little either their education or their religion had done to make them tolerant citizens. The chapter on education in my book is twice as long as any other chapter in the book, and is not over, as one can continually see conflicts over religious education, particularly in Quebec and Ontario of late. But schools were also a place where children of minority religions were excluded. In Ontario and Quebec, the Constitution guaranteed Protestant and Roman Catholic schools. So where were Jewish children or Muslim children to go? At one time, Jewish children were excluded from both school boards in Montreal, where the largest population of Jews in Canada resided. Jewish parents generally sent their children to Protestant schools, but they were treated as second-class citizens. A legal challenge in 1903 spurred an informal agreement to accommodate Jewish children in the Protestant board, but this resulted in yet another legal challenge that went all the way to the British Privy Council. This ultimately led to the formation of a school board for Jewish children in 1928, 25 years after the original legal challenge. Mennonites, like myself, are only too well aware of the thousands of Mennonites that emigrated to Mexico and South America after being denied the right to educate their own children. While the federal government had promised this to entice Mennonites to immigrate to Canada, the provincial government of Manitoba required all children in the province to go to government schools. Other religious minorities like Hutterites and Doukhobors faced similar challenges. This was a serious enough issue for parents that some went to jail and others left the country over it. The strongest restrictions on religious minorities, however, were experienced by Jehovah's Witnesses. I need to pause here and note that witnesses in the past were not as gentle and nice as they are now. It seems inconceivable that Jehovah's Witnesses would face what they did in the last century, but in their early days, the Jehovah's Witnesses published pamphlets referring to the Pope as the Antichrist. In 1928, their virulent anti-Catholic radio broadcasts resulted in the banning of all single-faith radio stations in Canada for decades. During the Second World War, Jehovah's Witnesses became a banned organization, the only religious organization to be banned. That made it illegal to be a Jehovah's Witness or to possess Jehovah's Witness literature. This was particularly challenging on school children who, during wartime, were more required to participate in nationalistic observances which were contrary to their religious beliefs. They were expelled for refusing to participate, but then their parents couldn't say that they were Jehovah's Witnesses or they would be jailed. In the 1950s, Premier Duplessis in Quebec commenced an all-out campaign against Jehovah's Witnesses. Over 1,500 were arrested. They initially faced charges for blasphemous libel, but when the Supreme Court of Canada did not allow that interpretation, they switched to seditious libel. Ultimately, that charge was also disallowed by the Supreme Court. Then witnesses were charged with violating bylaws that prohibited the distribution of literature. Duplessis was ultimately stopped by Frank Roncarelli, whose restaurant Duplessis closed down when he personally ordered that Roncarelli's liquor license be revoked. The seminal Supreme Court of Canada decision in Roncarelli and Duplessis, one of the first court cases one studies in law school, established the principle that government officials were subject to the law and could not act on the basis of personal bias in applying the law. Duplessis was personally fined for his involvement in that case. Even now, Jehovah's Witnesses face challenges as they refuse blood transfusions. This is accepted for adults, but children are made wards of the state if their parents refuse to consent to life-saving blood transfusions. While there is no age at which children are legally permitted to consent to their own medical treatment, generally mature teenagers are permitted to make their own medical decisions. Girls as young as 13, for example, are permitted to consent to abortions for themselves, but girls as old as 16 have been refused the right to consent to, or refused to consent to, blood transfusions. Whatever you may think of this practice, there is something abhorrent about forcing medical treatment on an unwilling person. Well, I've now covered the first two eras, that of Roman Catholic Protestant conflict and that of exclusion of minority religions. Jehovah's Witnesses and Jews lobbied the government to enact protection from discrimination on the basis of religion and on the basis of other human rights. Hundreds of thousands of people signed a petition started by the Jehovah's Witnesses. The first Racial Discrimination Act was passed by the Ontario legislature in 1944 at the behest of a Jewish member of the legislature. John D. Baker took up the cause for a National Bill of Rights in 1947, years before he became Prime Minister. When he was Prime Minister, this was his proudest accomplishment, and if you see the statue of him on Parliament Hill, he is holding the Bill of Rights of 1960. Because the Bill of Rights was not a constitutional document, however, it did not appear to give priority to human rights. It was considered quasi-constitutional. There continued to be pressure then, particularly from minorities, and most particularly religious minorities, to establish constitutional protection for human rights. Pierre Trudeau, who grew up in Quebec during the Duplessis years, was motivated to strengthen human rights protection. He had seen firsthand repression of Jehovah's Witnesses. Including human rights in the Canadian Constitution, however, was not an easy matter. First, the Constitution was a multitude of documents passed by the British Parliament. Second, constitutional protection for human rights needed to apply to all levels of government, not just the federal government, which required that the provincial governments also be supportive. We all know the stories and even the myths surrounding the 1982 adoption of the Canadian Charter of Rights and Freedoms. And interpretations under the Charter have not been without controversy, but the Charter brought in a new era of human rights protection. I will deliberately not tread too much into the current Charter era of religious freedom, as that is what my colleague Hutchinson will be addressing. But I will look briefly at the types of issues that are dominating religious freedom discourse. While Canadian society was already moving in this direction, court decisions under the Charter moved Canada more quickly into secularism. In one of the early cases before the Supreme Court of Canada, the court struck down Sunday closing laws as being coercive. It was coercive to force people to observe the Christian Sabbath. Court decisions related to education removed religious instruction and religious observances from schools. The result was that religion was privatized, removed from the public realm. A subsequent case ruled that this made Canada a secular country. But what does secular mean? Does it require that religion be excluded from public discourse, as some would argue? Does it rather require that neutrality be observed, both for religion and for non-religion? Or can it encourage religion but not participate in it? Can religion break out of its privatized box and engage meaningfully with secular society? Another current hot issue is that of competing rights. The hottest of these issues is the perceived conflict between religious freedom and equality rights for gays and lesbians. Only slightly cooler, depending on which day you read the newspaper, is the conflict between religious freedom and women's reproductive rights. Both these issues have garnered heated commentary nationally and very recently. Lastly, religious rights cannot be fully protected unless the communal aspect of religion is recognized. Religion practiced alone is called spirituality. Most religions are practiced in communities such as churches, mosques, temples, and synagogues. Because of the community aspect, religions found camps, shelters, schools, and universities. There is sometimes tension between individual members of religious communities and the community itself, but more often, those outside the community fail to understand the nature of the community. This can result in limiting religious practices. One current example of this is my university, Trinity Western University, which is criticized for having a community covenant adhered to by faculty, staff, and students. What people fail to understand is that the university is a community that students choose to participate in. Canada is a diverse, multicultural, and multi-religious society. Understanding our past helps us frame the current religious conflicts as part of our ongoing struggle to find ways to live together in harmony. The more we can dialogue and seek understanding, the more likely we are to be able to find positive and affirming ways forward.
Much, Dr. Buckingham. So you can be assured there's much more material in that book. That's a tough thing to do, to condense it to 15 minutes. All that's important, and there's lots left out. I want to welcome our next speaker, Don Hutchinson. Don has been asked to speak about the Canadian legal system, friend or foe of religious freedom. Join me in welcoming Don Hutchinson.
The Canadian legal system is composed of several levels of courts, a multiplicity of tribunals, and tens of thousands of lawyers, investigators, and police officers. In theory, all of these submit themselves to various legislative assemblies, from town councils and school boards to provincial and territorial governments, as well as the Parliament of Canada. Constitutionally, Canada is a parliamentary democracy. However, since 1982, increasing deference has been paid to the courts, particularly the Supreme Court of Canada. On April 17, 1982, I looked wistfully into the past. The day after my last exam in first-year law school, I pedaled my bicycle across town on a sunny Vancouver day to have breakfast at a friend's, to watch his color television. On a rainy day in Ottawa, our Constitution was brought to Canada from England. Along with the British North America Act crossing the pond and being renamed the Constitution Act 1867, the entire Canadian legal system was amended through the Made in Canada Constitution Act 1982. Key to this Canadianized component was the Canadian Charter of Rights and Freedoms, often referred to simply as the Charter. The Charter applies between government and government agencies, federal, provincial, municipal, school boards, etc., and the citizenry. It does not apply between private persons. Human rights codes, human rights acts, and bills of rights are constitution-like legislation, as Dr. Buckingham referenced, that apply to the relationship between non-governmental parties as well as between government and citizens within the provincial or federal jurisdiction of a particular code. In addition to a preamble recognizing the foundation of this nation upon principles that recognize the supremacy of God and the rule of law, the Charter is comprised of a series of brief statements negotiated by committee with the intention of summarizing the recognized rights and freedoms of the Canadian peoples after 115 years of Canada. Religious freedom, then, was enshrined. The first freedoms mentioned in the Charter are stated to be fundamental. One would think this to be a reference to the essential, primary, and underlying freedoms of the nation as a free and democratic society. However, the Supreme Court of Canada has determined that there is, at least theoretically, no hierarchy of rights. The first freedom listed is freedom of conscience and religion. Freedom of religion has been recognized by Brian Grimm and Roger Fink in their book, The Price of Freedom Denied, as the canary in the coal mine freedom, or to use another word, fundamental to any free society. In 2005, Canada was listed for the first time by the Voice of the Martyrs as a nation displaying early signs of a general, government-accepted persecution of Christians. The early signs are efforts to, 1, stereotype, 2, vilify, and 3, marginalize, simply because of one's faith. The Charter has compromised religious freedom to some degree, partly due to the application of Section 1, which states that the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. In other words, no right is absolute. The Supreme Court of Canada has settled on, again, a theoretically objective test for assessing whether or not laws and regulations established by various levels of government and government-authorized bodies are constitutionally acceptable. Reasonable limits. Reasonable limits require that the initiative must violate a right in the following ways. It has to be prescribed by law. It has to have a pressing and substantial purpose. It has to be reasonable and demonstrably justified. That is, it has to be rationally connected to the law's purpose and result in minimal impairment of the right in question. And finally, proportionate to attaining the intended effect of the law. Section 1 analysis of the violation of freedom of religion has set components of the Canadian legal system and the Canadian public at odds with one another. In addition, the Supreme Court of Canada has interpreted Section 15 of the Charter, which provides for equal protection and equal benefit of the law, as providing rights for analogous categories of rights to those listed in the Charter. Perhaps the most contentious recognition has been to an analogous right of sexual orientation, which has set up a direct competing right with certain religious beliefs and practices. The interpretation of Section 15 in this way arises from the drafter's use of the words "in particular," which the court determined to refer to examples of an open list rather than a statement of a closed list. In short, the Supreme Court of Canada has described the Constitution as a living tree that changes with time, rejecting the concept that the Charter is a record of the foundational democratic freedoms established in the first 115 years of the Canadian legal system. Religious freedom defined. The first case to reach the Supreme Court of Canada on the constitutional right to freedom of religion was not a personal claim based on religion, but a commercial claim based on a desire to open an Alberta drugstore on Sundays, which 3 decades ago was a violation of federal law. The court set out a robust definition of religious freedom that mirrored the wording in Article 18 of the Universal Declaration of Human Rights. The right to believe, the right to share one's beliefs openly with others, the right to worship, the right to practice by living one's life according to one's beliefs, as well as to teach and disseminate one's beliefs. This was a bold definition that echoed the historic development of religious freedom in Canada. As the court continued, however, it placed restrictions on freedom of religion based on terms that have proven to be uncertain in law, injury or harm to one's neighbors, or their parallel or competing rights. And ultimately, the court introduced the concept that religious freedom includes the right to be free from religion, or government action that gives the appearance of religious imposition. The centuries-old concept of government and religion working cooperatively together was supplanted with something akin to a Canadianized version of the American doctrine of the separation of church and state, notwithstanding the court left our constitutional monarchy intact, even though the Queen is also the head of the Anglican Church. The Sunday voting law, unsuitably named the Lord's Day Act, was struck from the books. A year later, the court affirmed that religion has both individual and collective aspects. Then the judges noted that laws impacting religion could be made by any level of government, based on the constitutional division of powers. And any law perceived to have a religious purpose would be found unconstitutional. Religious freedom has since been refined in the Queen and Grunke. In 1991, the court affirmed the right to privileged communication between clergy and parishioners, and then undid the privilege based on the state's need for evidence to secure a conviction in a murder trial. There were also 3 very friendly decisions of the court that refined the constitutional position of faith practices associated with sincerely held religious beliefs. In Amsterdam and Maltani, the court found that neither it nor government should be the arbiter of religious beliefs, or the diversity of state practices associated with those beliefs. The court also determined that other state decision makers had to make their decisions in the context of the Charter's guarantees. Both of these decisions were applying to the individual what the court had decided for a community of believers in the earlier case of Trinity Western University and the British Columbia College of Teachers. In that case, the court endorsed the concept that the diversity of Canadian society is partly reflected in the multiple religious organizations that mark the societal landscape, and this diversity of views should be respected. End quote. The school could teach education, and the graduates could teach in the public school system. Most often quoted by opponents in the current debate around Trinity Western establishing a law school is one line from the decision. But let's look at that line in its context. And when we do so, what we find the court saying is education is about meeting educational standards. Professional practice is about meeting the practice standards of one's profession. Context is important. Religious freedom revisited. As recently as 2009, the court affirmed the principles in Trinity Western and Amsterdam in its decision in Alberta and Batarian Brethren. However, in that case, Chief Justice McLaughlin and the majority then took a new departure in regard to religious freedom. While recognizing the individual would be deprived by the law because of their religious beliefs, the court concluded that the community could bear the additional costs imposed. In effect, the duty to accommodate was shifted from the state to the religious believer and the religious community. This opens the door to put pressure on individuals and communities to change their non-harmful religious beliefs and practices based on a burden imposed by the state through law or regulation. The decision in Chamberlain resurrected the preamble of the Charter after many had buried the Charter's reference to the supremacy of God. The court defined the concept of a secular society as one that embraces the religious people in its midst in all aspects of the life of that society. The court concluded that everyone has belief or faith in something, be it atheistic, agnostic, or religious. Some object to any influence being given these words written in dissent by Justice Conche. However, the Chief Justice, in her decision on behalf of the majority, noted her agreement with him on this point and other points in his decision. In the end, however, the court sent the decision back to the school board with strong language encouraging the school board's final decision to hear the religious objections of the majority, but be inclusive of the position of the minority. In 2013's Wakhat decision, the court offered constitutional protection to sacred texts, such as the Bible, affirmed that religious principles are welcome in the public square, and set aside the allegation that speech that hurts someone's feelings was to be considered as hate speech. But the court noted the importance of context, and the context in which the scriptures are used, the context in which religious principles are expressed, the context being important in determining the appropriateness of what is being expressed, stating that if the communication could be reasonably perceived as targeting an identifiable group, it might be considered hate speech. The court offered a strange no decision. I thought that only happened in boxing. They offered this no decision ruling in the SL case in 2012. The court affirmed the state's role in setting educational requirements, as well as the right of parents to raise children in their own faith beliefs. However, the court essentially disqualified the case because the parents had not demonstrated that the proposed education program to which they objected had actually caused any harm to their children. This was a departure from the long-endorsed concepts of prevention of harm or potential injury. The court did acknowledge that the state is not capable of being fully neutral and declare that the state should neither favor nor hinder any particular religious belief. The bench also remarked that this non-decision did not favor the government's position, and essentially the issues were presented before the court again this March in the Loyola case. This, friends, is just a sampling of one branch of the Canadian legal system's treatment of freedom of religion. We haven't touched on the treatment of public school teachers who advocated religious principles on public policy matters, or marriage commissioners removed from their position because of their religious beliefs about marriage, municipalities' efforts to zone out religious presence, or human rights tribunal decisions that have required faith communities to change practices connected with their sincerely held religious beliefs, or the finding that a song called "Kill All the Christians" was not hateful. If there indeed is no hierarchy of rights, then freedom of religion is in second place, when it should be tied for first, with all the other rights recognized under the Charter. Human rights in Canada have been mistakenly applied to protect perceived minorities rather than to support all Canadians. Is the Canadian legal system a friend or foe of religious freedom? I'd say it's more like Dr. Jekyll and Mr. Hyde. Thank you.
Our final presenter is Professor Natasha Bakht. She will be presenting on recognizing and responding to the seeds of religious intolerance. Join me in welcoming her.
pleasure to be participating in this forum. Let me start by acknowledging and thanking the Algonquin peoples on whose unceded territory we are on. So I'm going to be talking today about recognizing and responding to the seeds of religious intolerance in Canada, but I'd like to do it by using a case study. So the Western world is at an astonishing historical moment, when in the 21st century, women's clothes are the subject of legislation, judicial consideration, and much public approbation. And I'm thinking in particular about the situation of Muslim women who wear the niqab, or the full face veil, and the growing agitation that has been expressed about these women publicly. There are a variety of reasons offered in support of the belief that women should not be permitted to wear the niqab in certain venues, and some of these include the niqab oppresses women, it prevents integration, it offends secularism and tolerance, it decreases security and communication, it's impolite, it encourages proselytism, and it is not a religious requirement. Well, I'd say that the niqab cannot be understood as a symbol with singular meaning. There is a new report coming out of Ontario produced by the Canadian Council of Muslim Women that actually interviews niqab-wearing women and finds that the reasons provided for wearing the niqab are highly personal and diverse. So contrary to the prevailing view that male family members force niqab-wearing women into this attire, the study suggests that many women, in fact, faced familial opposition to their very personal decision to wear the niqab. So the report really puts into question the contention that we must rescue niqab-wearing women from oppression. In fact, the decision to wear the niqab, or any clothing for that matter, is likely a strategic choice made in always already constrained relational environments, where costs and benefits vary depending on the circumstances. So instead of being a unilateral instrument of submission or free expression, the preference to wear the niqab is shaped by multiple interactions and regulation. My research has shown that niqab-wearing women are not the submissive women that society believes them to be. They are, in fact, acting as advocates in courts of law, teaching in schools, pursuing higher education, litigating their rights in courtrooms, and interacting with male cabinet ministers about issues of concern to them. So the niqab is a critical component of who they are. To deny them access to fundamental legal institutions on the basis of their identity is, I would suggest, to deny their dignity. People often tell me, because I write about this subject, how uncomfortable the niqab makes them feel. Well, I would suggest that comfort is an ineffective measure for interactions in a diverse society. Nonetheless, I've tried to really consider what it is that makes us so uncomfortable. At one level, I believe it is simply fear of the unknown, or fear of that on which we have inscribed ideas of radicalism and terrorism. I would not be surprised if many of you have never met a niqab-wearing woman or spoken with her. Fear, like discomfort, is a bad advisor. Dr. Catherine Bullock has suggested that our discomfort is about the interpretation of the gaze, G-A-Z. That with the niqab-wearing woman, she sees us, but we do not see her. So she subverts the typical power relation in that she sees, but is not seen. Another explanation is the origins of the dominant Western scopic regime, in which vision is central to the fact of marking Christ as the observable earthly image of God. So Valérie Léry argues that the Christian West's foundational ocular centrism has led to secularism. Well, whatever the reason for our dislike of the niqab, and there may be others, to live peacefully in a diverse democracy, we need to develop empathy that enables us to see the world from the point of view of others. I'm going to concentrate my remarks today on Canadian prohibitions or attempts at prohibiting the niqab. These debates are, of course, happening with rigor in other parts of the world, including Europe, the UK, and the United States. But amazingly, in Canada, we have had 4 incidents in which niqab-wearing women feature prominently. 1. Veiled voting. Identification arguments play a key role in claims to ban the niqab in public spaces. Veiled voting became an issue in Canada when the federal government introduced Bill C-6, an act to amend the Canada Elections Act for the visual identification of voters. This bill, which was introduced in 2007, requires voters to have their faces uncovered to enable election officials to identify them visually, even though there would be no means of taking a visual comparison of the voter, because the person can present 2 pieces of non-photo identification in order to vote. So this irrational insistence on seeing one's face apparently defies logic. The bill, which died when Parliament was prorogued, was an attempt to prevent voter fraud, although there's actually little evidence of a problem with voter fraud in Canada. The bill was really an attempt to counter the problem of the mythical, multiple voting veiled Muslim woman. As one Globe and Mail editorial put it, showing one's face would only prove that the voter has a face. So the question that arises when unfounded and unexamined objections to the niqab are raised is whether the restriction on attire is actually a subterfuge for discrimination. In the veiled voting incident, identification was clearly not the real concern. 2. Citizenship ceremonies. In December 2011, in a unilateral move by Immigration Minister Jason Kenney, face veils were banned during citizenship ceremonies. Minister Kenney was able to make this move without any consultations because the changes were made under the regulations to the Citizenship Act. The reason for the change was that some MPs and citizenship judges had complained that it was hard to tell whether people with their faces covered are actually reciting the oath of citizenship, which is a requirement under the Act. So, women who have overcome all of the concrete hurdles to Canadian citizenship, which are by no means minimal, are denied this coveted privilege because of complaints from some that they are not engaging in the symbolic act of declaring one's Canadianness. So niqab-wearing women, it seems, cannot be trusted to pronounce the words of the oath. We need to actually see their mouths moving. Minister Kenney also said in his explanation for the new regulation, and I quote, allowing a group to hide their faces while they're becoming members of our community is counter to Canada's commitment to openness, equality, and social cohesion. End quote. His comments, I believe, disclose a very particular and polarized construction of us as insiders and them as outsiders. Sara Ahmed argues that she examines the figure of the stranger in multicultural discourse in Australia. And she suggests that the nation requires strangers in order to exist, in order to set the limit of the nation. And she suggests that multiculturalism may seek to differentiate between those strangers whose appearance of difference can be claimed by the nation, and those strangers whose difference may be dangerous to the well-being of even the most heterogeneous of nations. So while some outward appearance of difference can be assimilated, so long as the person is the same underneath, the dress of some strangers, niqab-wearing women in particular, is simply the outward representation that the stranger refuses to be native. 3. Niqabs in courtrooms. In R&NS, the Supreme Court of Canada examined whether a devout Muslim woman, sexual assault complainant, could wear her niqab while testifying in court. MS is a Muslim woman from Toronto who was worn her niqab for over 80 years and alleged that two male relatives sexually assaulted her over a period of several years. The lawyers for the accused objected to NS, or the complainant, wearing her niqab. And they argued that in order to effectively cross-examine the complainant, they needed to be able to see her face, to gauge her reactions to their questions. And they also argued that the trier of fact would have difficulties making credibility assessments unless they could see her face. So as you may know, judges and juries are permitted in law to assess the credibility of witnesses and the accused based on demeanor evidence. That means that they are permitted to evaluate the trustworthiness of a person in court based on their appearance, their attitude, or their disposition. And much case law exists to support this contention. But there's also a growing body of case law and social science literature that warns judges about the excessive use of demeanor evidence because of its inherent unreliability. It's very common for individuals to believe that they can determine when they are being lied to. But Professor Paul Ekman, in his study of lying, found that with rare exception, no one can do better than chance at spotting liars simply by their demeanor. In racial profiling cases, perfectly innocuous behavior is often interpreted as suspicious simply because the observation was occurring through stereotypical lenses. In the sexual assault context, the concern is that demeanor evidence will result in reliance on inappropriate myths about the way women ought to react to sexual assault, penalizing those who do not fit those rigid characterizations. It's women's words that matter, not women's bodies, or how we look, or what we are wearing. So the NS case really challenged a foundational premise of our legal system, that those who see the witness are at the greatest advantage. The social science literature strongly suggests that this is not the case. The question was whether the Supreme Court of Canada was willing to overhaul our system accordingly. It did not. The majority decision doesn't prohibit niqab-wearing women from courtrooms outright. Instead, what it does is it provides trial courts with an analytical framework to structure their reasoning, but it is one that skews the balance in favor of a ban of the niqab more often than not. The court has said that when evidence is contested, the woman can wear a niqab. Well, in sexual assault cases, the evidence is necessarily contested. He said one thing, she said another. The majority's concern that the accused's right to a fair trial is, of course, important. But interestingly, they failed to consider their own guidance from a previous case called Mills, in which they said what constitutes a fair trial is consideration not just of the rights of the accused, but also the public interest in the prosecution of criminal processes that are sensitive to the needs of victims and witnesses. The effect of the NS judgment will be that niqab-wearing women will be less likely to report their sexual assaults, which is already an underreported crime, thus renewing rape myths about the way sexual assault victims ought to appear. The decision further marginalizes an already stigmatized group and tells them that justice will not be done for them. 4. Bill 60, niqabs and public service. So the province of Quebec, as was mentioned, was until recently embroiled in a debate about the Charter of Quebec values. This bill proposed to amend the Quebec Charter of Human Rights and Freedoms by, among other things, making it mandatory to have one's face uncovered when either providing or receiving a state service. Essentially, niqab-wearing women, and indeed all people who wear conspicuous religious symbols, would have been prevented from working in government service, despite their competence and training, simply because of an unproven legislative assertion that they would be unable to perform their jobs neutrally or without religious bias. Niqab-wearing women and no one else would have also been prevented had this bill become law, from accessing government-run services such as childcare, healthcare, and education, despite the contention that Bill 60 was in part about the equality of men and women. We continually hear that the niqab is a symbol of women's oppression, but there's actually no evidence that the wearing of a religious garment is causally related to inequality between men and women. Rather, restricting public employees from wearing garments that they sincerely believe to be required by their faith subverts gender equality, as it could make Muslim women more dependent on the patriarchal sectors of their communities by further estranging them from the public sphere. Education and employment are some of the best means to ensure integration and autonomy if you're really concerned about women's rights. The state should never be in the business of telling people how to dress. In my view, the major oppression that these women face is coercive and state-sanctioned attempts at removing their clothing publicly, and discriminatory attitudes and systems that prevent them from effectively participating in all parts of society. Now, although all federal political parties denounced Bill 60, it's very telling that there was very little concern over the bill's predecessor, Bill 94, which targeted only niqab-wearing women and not all people who wore religious symbols. Bill 60 did not become law, but the Quebec government's backing of these discriminatory ideas legitimized and emboldened public views, and we saw an increase in acts of vandalism, reports of harassment, and acts of anti-Muslim intolerance, from spitting to racial insults. In recognizing the seeds of intolerance against niqab-wearing women, one might want to consider the incongruous messages deployed about them. The veiled woman is both threat and threatened. The equality of niqab-wearing women is threatened, and they are in need of rescuing from their male oppressors who force the niqab upon them. But they are also threatening in their attire, in that they wear, in the clothes that they wear to hide their identity, to defraud the electoral system, to prevent a fair trial, and to prevent open communication with the state. So these mixed messages reinforce a conception of us and the nation as secular, equal in relations between men and women, and religiously neutral, whereas they are wholly religious, unequal, and repressed. The nation can be inclusive of some, but niqabi women take things too far. She must remain other. Indeed, these examples shore up the pervasive belief that wearing the niqab is a practice that asks too much of the rest of society. These ideas seep into mainstream consciousness and lower the bar in terms of what can appropriately and publicly be said about Muslims, and indeed what can be done to them. The integration of Muslims is articulated as a problem, but its cause is located not in society with its systemic barriers to inclusion, but in Muslim women's choice to veil. I'd suggest that it's only by considering the plight of the most marginalized that justice can be achieved. Thank you.
Thank you, Professor Bakht. We want to allow you to take a 5-minute break before we move to the panel discussion. We're going to have all of the presenters here. There are 2 open microphones. There will be an opportunity to have questions and comments. We do want to allow you to stretch your legs for a moment. There's coffee, juice, tea in the back. The washrooms are back the way you came in to the front doors and turn right. However, we're going to be very strict on the 5 minutes, so we encourage you to get back to this as quickly as we can.
Thank you. I want to welcome everyone to the second half of our evening here, which is a discussion of some of the things we've heard this evening. My name is David Anderson. I'm member of Parliament for Cypress and Grasslands. We've been privileged to be organizers of the previous 3 forums that we've had. Many of you have been at out to some of those, so it's good to see some familiar faces. And we're certainly very glad to have Colin with us host this forum as well. So I'd like to welcome and acknowledge Mr. Sorensen and Ambassador Natasha from Afghanistan. Very thankful to be here tonight, colleagues, ladies and gentlemen. It's just an exciting time to be able to get together in a country where we can discuss these issues. And I particularly want to acknowledge the folks that work with me, Anna Marie, Joycelyn, and Craig, who have done the work that you see come together tonight. And I want to acknowledge Gail, Craig's wife, who's here on her birthday evening. That's the sacrifice made for religious freedom issues. But anyhow, we want to have a discussion. We want to give you folks a chance to be involved in this. We've done this at other forums, and it's a very good discussion. We'll use the same rules we've used before, which is that we will operate from a position of respect for each other, and certainly we expect that, and we don't cut anybody off who is not doing that. And secondly, we'd like you to be fairly brief. A minute or 2 minutes is good. If you can make your point in that time, and then we'll give the panel up here the opportunity to respond to you. And certainly we've had very different presentations tonight, some very different material, and yet some things that I think should soak deeply into our thinking. So we'll certainly invite anyone who would like to come to the mic, and if there isn't anyone right off the bat, I may ask a question, but I think we've already got someone coming up, so we'll compliment. And please introduce yourself if you're comfortable with that. We have some folks who aren't always comfortable with that, but if you can, please do that.
Sure. My name is Doug Noble. My question, I guess, best addressed to John Hutchinson. My question is best addressed to John Hutchinson. What obligations are there for employers to grant religious freedoms in their offices, outside of office hours, perhaps at lunchtime and so forth? And how does the notion of tolerance fit into that? You talked about freedom from religion and freedom of religion. And so I guess part of my question is that I feel that the term tolerance has changed over the last decade or two, from something that is more put up with somebody else's ideas to now to encourage the individual expression of whatever.
Yes, tolerance used to be more akin to the word we would use now as acceptance, accepting the other. And the word tolerance sprung out of that concept, and it has drifted towards, well, I'll put up with it if I have to. And when it comes to employers, employers also cover that range of expressions. I'll accept you for who you are, and I will facilitate that readily to, I'll put up with you if I have to, and just make me accommodate you. Employers, of course, run the gamut from private employers in industry to government employers. Human rights codes and the Human Rights Act federally apply in the particular industries to the private employers, and the human rights codes and acts are to be interpreted with principles that are expressed in regard to the Charter. Federal employers and provincial employers have the added obligation of being government in relationship, and so they have, I believe, added obligations under the Charter in accommodation. So the issue is fair and equal treatment as well as accommodation. So, for example, if someone is applying for employment and their religious beliefs, which based on Trinity Western, Amstel, Unitarian Brethren, the individual religious beliefs would require that they wear a hijab, a niqab, a kippah, or some other, a turban, other religious paraphernalia. They should not be discriminated against but accommodated on that basis if their particular religious practices would not be damaging to the workplace, but require setting aside time for prayer or for other purposes. They should be accommodated. And then in the best interests of the other employees who are there, if religious practices do not absolutely make those kinds of things mandatory, but the company or government is providing optional space and going beyond that to other groups, book clubs and things like that, then religious groups should not be required to not, as it were, have access. They should have equal access to that office space, for example, on their free time, to have a Bible study or a book club, to raise funds for the United Way, et cetera, et cetera. Does that help?
Yeah, I think so. Thank you.
Thanks. I would just add that generally employers have a duty to accommodate religious belief to the point of undue hardship. So the question becomes, what's undue hardship? And undue hardship will mean different things in different contexts. So if you're a small employer, and somebody wants to take a particular day off work, that's going to mean something different than, say, if you're a hospital that employs hundreds of people. So the question always becomes, what is undue hardship? Context becomes really important. It's hard to talk about broad principles beyond what we just said. They're very dependent on facts.
Very good. Thank you. Okay, we'll go to the mic at the back of the room.
Hi, this is my name is Don McMillan. I'm just a regular Canadian citizen. I'm not a lawyer, but I would like to make sure people in this room are aware of my views, that I'm opposed totally to anyone being allowed to vote if they're wearing a face mask, regardless of the reason why they're wearing a face mask. Whether they're religious or non-religious, you should be able to identify yourself before you vote, before you get on a bus. There's constant abuse taking place today, people taking advantage of wearing different headgear. That's not right. And at least the very basic, the basic rule has to apply to voting, which is our fundamental right here. I can't believe that someone would even argue that it's permissible to vote without showing your face. That's totally wrong. And you got to go back to school. If that's what they teach you in school, that's terribly wrong.
We'll let somebody respond to that if they would like to.
I guess I'm the somebody responding to that. Well, I would agree that you need to identify yourself before having to vote. And as I mentioned, one way in which to identify yourself is to provide two pieces of photo identification, two pieces of non-photo identification as required by the Canada Elections Act. So some people don't have photo identification. They may have a World Health Card, they may have a social insurance number. That's sufficient to get you on the voter list. And so if that's sufficient, there shouldn't be a need to then show your face. So I don't really think it is wrong. I think that we've sort of come this far without people having to show their face. And I think it's a little different if you're, to sort of equate a niqab with a face mask is, some would say a little derogatory because it sort of depends on why, you're covering your face. We don't protect everything under the Charter, but we do protect certain things if they're done for Charter-protected reasons. And having a sincere religious belief that you have to cover your face under certain circumstances or conditions is Charter-protected.
The Amstelveen decision is hated by a lot of governments across this country. And the reason it's hated is because it ties the practice to the individual's personal, sincerely held religious beliefs, rather than saying you've got to find a rabbi or an imam or a priest or a pastor who will say that what you're expressing is legitimate. In Ontario, a particular issue has arisen with the Pastafarians who like to get their driver's license photographs taken with spaghetti colanders on their head. And that has been found unconstitutional. When it comes to voting, we can look at religious freedom and recognize that religious freedom, for one, ties into religious freedom for all, and that we have a lot of things that need to be dealt with in regard to voting equality. So if one requires photo ID for voting, then Ontarian brethren who do not agree to having the photographs taken will be disqualified from voting in colonies all across the country. If one accepts 2 pieces of non-photo ID as adequate identification, then it wouldn't matter if Member of Parliament Colin Mays showed up with 2 Don Hutchinsons, or if Don Hutchinson showed up with 2 Colin Mays. How do you tell that we're not the other? So that in the case of our voting requirements, the equal treatment of Canadian citizens is what's at issue. And as I understand the Amsterdam decision, if the niqab is being worn by the individual expressing a sincerely held religious belief, that is to be accepted by the state under the Charter.
Okay. Please.
My name is Rabbi Aryeh Sharp. And first of all, I want to say happy birthday. Second of all, and I mentioned this privately, Professor Bakht, I want to thank you very much for making people uncomfortable here this evening. And I want to respond a little bit to some of your very articulate argument. When I hear the word niqab, I think of the Hebrew word nekavah, which means female, and is related to the Hebrew root to cover, to conceal. When I think of niqab, I think of the story in Genesis, Breshit to those of us who understand Hebrew, where Rebecca, is being introduced to Yitzchak, Isaac. And she's on the camel, she's come from Iraq. Eliezer, the servant, is leading the camel into the compound, and Isaac comes out of the tent, and the first thing Rebecca does is veil herself. It's part of our culture. The fact that we don't do it today is one thing, but the fact that we did it must be accommodated. When Jewish women from Yemen were coming to Israel in 1949, they were coming wearing niqab and henna. And they were forced onto secular kibbutzim, where those traditions were removed steadily. And it caused tremendous social disruption that is ongoing today in the state of Israel. So I wanted to mention that just to provide some context for what it was that you said. And I'm wondering if I could get some feedback from the panel on specifically what your opinions might be with some of the issues that Professor Bakht, very articulate young woman, raised here this evening.
I would respond to Professor Bakht talked about relegating people as the other. And this is one of the key issues. And I teach a course at Boston University on religion and American foreign policy. And one of the things that we look at is how in America some of these same issues are faced. And historically, there has always been, in American religious society, an other to which the majority shaped laws and shaped society to exclude. First, at the very beginning, America was established as a dominantly Protestant society, not Catholic. And the Catholics were excluded. Then eventually the Catholics were included and the Jews were excluded. Then eventually the Jews were included and the Muslims are excluded. We're always trying to find somebody and some reason to exclude. And if we are going to talk about cherishing freedom, freedom has to be inclusive, and it has to allow things that make us uncomfortable. Because guess what? I probably make some people uncomfortable. And if I want the freedom to be who I am, whether it's in Canadian society or American society or any other liberal democratic society, I must grant that to everyone else.
I would just respond, Rabbi. I'm really interested in the cultural references, and I've sort of in my research have also come across a lot of communities who where the niqab is part of their culture, and then I'm often confronted by Muslims today who will say that's just it. It's culture. It's not religion. And so, how do we? And Minister Kenny, when he was explaining the reason for why niqab wearing women will not be permitted to say the oath with their niqabs, said it's not really a religious requirement, it's cultural. And I guess I would just want to sort of reiterate what Mr. Hutchinson has talked about, and that is the way in which religious freedom is understood in Canada and internationally. And that is that it's a sincere religious belief. So it doesn't matter if your imam or the majority of the believers say that the niqab is not a religious requirement. What matters is what you personally believe. And some have been critical of this test because they say, where do we draw the line? Anything goes. And those are fair points. I like the test because I think it protects the idiosyncratic dissenter. And often in religious communities, that's women. Right? So I want women to be empowered to be able to say, this is what my religion says is required of my faith, notwithstanding what the religious leaders who are typically men will say.
Well, and since we moved on to the point of the oath of citizenship, one of the very key things about the oath of citizenship is that a person who is being administered that oath is saying the words. There's a whole other dispute about people who want to say the oath except for certain words that they don't want to repeat. And my uninformed solution would be to accommodate the sincerely held religious beliefs of the niqab-wearing woman to find out who she can show her face to. I don't know well enough. I understand from some imams that some women who, based on their sincerely held religious beliefs, feel comfortable showing their face to other women in a private setting, could have a private citizenship ceremony with a citizenship judge and acceptable witnesses, and then her lips could be washed, and it could be understood that she's saying the oath. Because that component of the oath of citizenship has become vital in our culture, to the point where this young gentleman down on the end here, when he was adopted into the nation and had to say it himself, was advised beforehand that one of the key things that happens is there are witnesses who will be standing before you, watching your lips to make sure you say the entire oath, because that's vital to citizenship.
Okay, let me add to that just one minor moment. When my family took the oath of citizenship, my wife had a real problem with just one part of that, and that was that you have to swear your allegiance to the Queen and her heirs in perpetuity. And my wife had a little bit of a challenge with Prince Charles. And so she said she wasn't going to say that, and I said, well, if you don't, then it doesn't count. And they'll be watching you. And I said, so we went through the thing, and I said, so what did she do? She said, I moved my lips, but I didn't say anything.
She will have to be recorded. Well, you were there. I hit the front mic first, and then we'll go to the back. Is it already on?
Yeah, no, just Don, for your uninformed opinion, I know we know each other.
What's your name?
My name is, thank you, Dave. My name is Bob Zimmer, member of Parliament, third church, whichever. But we've noticed of late, and I lived through the Trinity years, I went to Trinity years, there too. full decision. But I think we have an issue with the Supreme Court of Canada and the judgments that it's making. Now, I'm going to ask you how to fix that court. That presumes it's broken. But I leave this open for any panelists to make a comment towards this. How do we fix this?
That's the job of politicians.
Respect and brevity, right?
Well, part B of my question is we are supposed to be a separate arm from the courts. And we respect that the court judgments are who the Supreme Court is. So it's not our job. We're to give them laws to enact, but when they say your laws are not going to enact, something's broken, and that's what I'm asking for the fix. Elected Supreme Court doesn't happen in the US, doesn't happen in Canada, but what would you say would fix? And another term that's it's an American term is checks and balances. To me, I see it lacking in Canada right now, checks and balances to the Supreme Court. So how do we fix that imbalance? And I will come back up again if you promise to.
I actually wasn't referencing the laws, I was referencing the appointments of judges. But I would agree, and actually, there are a variety of areas where the Supreme Court of Canada doesn't seem to have coherence. And if I admire Don for trying to bring some coherence to the body of law on religious freedom, which seems to, lack consistency, to put it gently. And so you would go to court. You would think you're going to the Supreme Court of Canada, you should know, based on previous cases, previous decisions, what they're going to decide in the next case. But it's always a surprise. The reasoning is always a surprise. And that really should not be happening with the Supreme Court. They should be consistent with their previous decisions. He has an answer.
The solution, part of the solution to the Supreme Court of Canada making some decisions based on 9 or fewer judges' understanding of what's changing in society and how that impacts the law is that we have elected legislatures which, even under the Constitution Act of 1982, have the authority to enact legislation overriding conclusions of the Supreme Court of Canada, and to a degree it's been the laxness of politicians in not using that clause, and I know that when it's been used it's been a poison pill for a few. It's been laxness in not using the notwithstanding clause that has created a deference to the court that surpasses the deference that is properly owed to Parliament and the provincial legislatures.
Our commitment is to have everyone out of here at 9:15. I think we can handle the 3 questioners that are at the mic. If anybody else is desperate, they may end up being the last person to come to the mic, but we'll go to the back of the room, please.
Hi, my name is John Adeyefa. I'm a Canadian citizen. I've been living in Ottawa for the past 36 years, but I grew up in Africa. Dr. Wallace mentioned by ending his speech that Canada is a refuge for many religion and faith. My question is, how do you maintain and keep this for the future? The main reason I'm saying this is because right now, in some countries in Africa, there has been some radical people just decide to start doing hate mongering and calling for killing the other religions and also burning churches and so on. From the legal and the law enforcement perspective, how do you maintain this status in Canada so that it should be a refuge for many religions and faiths?
One of the things we have to do is what I was saying earlier, and that is that we truly have to have freedom for people to believe and even express beliefs that are antithetical to our own, and allow that. and cherish their freedom to believe something we do not believe in order to be a refuge for all, not just a refuge for those that agree with me. And once we start in defining the kind of refuge we're going to be, we will quickly find ourselves excluding more and more to the point that someday we might be excluded. So, I think Canada is that refuge. Other countries are, but I think Canada is unique and is respected around the world in that way. But to do that, we have to be inclusive. And we have to put up with that which we do not like. Even if it means some people wear clothing we're not personally comfortable with. Some people observe religious practices that we're not in agreement with or comfortable with. Because we want the freedom to practice and hold our own beliefs. To me, it revolves around freedom in order to be a refuge.
If I can just add to that, it also is a responsibility of all people who have a religious faith to stand up for religious freedom for everyone, not just for ourselves, but to extend to, and I think that's just, sort of extending what you said, extending to others what we would ask for ourselves.
Hi, my name is David Smith. I'm pastor de l'Église Baptiste de Louis, pastor of the Bible Baptist Church of Ottawa in Canada. I was also a public school teacher before I went into ministry, and I still do substitute teaching in public school. I had 3 children gone through the public school system. One just graduated from university, one just entering university, one in secondary school. The subject of my question, several panelists mentioned secularism or sort of neutrality in areas of society. Particularly, I'm thinking of public schools where naturalism or secular naturalism can also be considered a religion of sorts, or at least a philosophical worldview, is being taught exclusively without other considerations such as the consideration of teaching scientific evidence for creation, along with that when there is evidence that supports that in the scientific society. I wonder if some panelists could address that.
Two aspects of this I'll try to quickly articulate. One is that the secular, if you read the literature about secularism, particularly I will call upon the model that Jose Casanova, who's now the Berkeley Center at Georgetown, is widely quoted at. There are different dimensions of the secular. The word secular comes from the Latin word saeculum. And this goes back to the Middle Ages, where the saeculum was the world. It was, you had the cloister, the church, the monastery, and you had the world. And the world was the saeculum. Okay? It was not necessarily a bad thing, that was just what it was called. And a priest could be considered a secular priest. And what that meant was he left the cloister, he left the church, and he went and he did his work out in the saeculum. Francis of Assisi would be an example of that. So he was considered a secular priest. So to say something is secular is not necessarily to say it excludes God or it is against God. There are different dimensions of that. There's a process of secularization whereby society is less ruled by the rules of the church or religion and more the rules of government and law. It's part of the transformation that happened in Quebec during the Quiet Revolution. What you're talking about, when we apply the word secular or secularization or secularism broadly, sometimes we do a disservice. What you're talking about when you're talking about
when you're talking about scientific evidence for creationism and the teaching of that in the public schools or the not teaching of that in the public schools. You're dealing with several different arguments here. One is the idea of secularism or naturalism or humanism. You can sort of parse those how you want to parse those. Then you get into evidence of science and the science of the origins of the universe. And the challenge is when we sort of mesh those together, we have a difficult argument. The same problem is being faced in the U.S., and it's argued over. And I don't think there's a clear answer for how public schools deal with this. And I don't have a ready-made solution for that. I think we do a disservice, though, when we take what some consider a scientific argument about origins, and we mix that up with the religious and philosophical discussion about the secular and secularism and secularization.
Okay, we're going to we can't take any more that are already up there, and we'll have to go fairly quickly on the ones that are.
I just want to quickly say that our education system in Canada is seriously damaged with some pockets of health. And the reason for the damage is increasing effort of particular governments to take control of education instead of to provide a framework for education and allow parents to control education. The different agreements that Canada has signed at the United Nations internationally, and the way our own laws have been structured really give the authority for education to parents. Parents pass that off to the education system, and what we've seen increasingly is government taking that control, to the point where homeschoolers in Quebec are fearful of whether or not they can school their children, even if they're meeting educational needs from the Catholic schools. And we see in Ontario 4-year-olds going into full-day school programs. Kids got to play. Kids learn through play, and then they end up in school and learn from their friends. And at what point in time do we say the government has enough control over it?
Go to the back of the room.
My name is Natasha. You write extensively on the Korean enlightenment and the prophet of the website called Florida.ca. I've got a very, very short question. Okay? Alright, let's do this again. My name is Natasha. Okay? I write extensively on the Korean enlightenment and the prophet of a website called Boreal.ca. I've got a very short question. Okay? Face recognition software now is key in identifying terrorists before and after the fact. How many lives would you sacrifice to the right of a woman to hide her face?
No questions for me. Niqab-wearing women remove their niqab in all sorts of situations. They do it, for example, at border crossings.
But you would deny them to do that, because all everything that you said that actually we don't go far enough in allowing them to wear the niqab wherever and whatever they want. Is basically that's your argument throughout that you basically gave 1 hour.
Okay, let's let her respond.
That's not what I said. I'm not saying that niqab-wearing women should be allowed to wear the niqab in every single circumstance. I don't think they want to wear the niqab in every single circumstance. What I was pointing to were places where they have been prohibited from wearing the niqab. So niqab-wearing women do take off their niqab, for example, when they need to go to the airport. The accommodation that they request and that is granted is that they show their face to a woman, authority official, who can then compare her face to a passport, for example. So face recognition software is, you're right, it's up and coming. It's certainly something that the Supreme Court of Canada has talked about in the context. Face recognition software is around. The Supreme Court of Canada has certainly talked about it in the context of the Hutchinson Brethren case. They put the emphasis on requiring, they gave the how best to put this. They allowed the Alberta government to say that a few hundred people who don't want their photos taken for reasons of religious objections, that those religious reasons have to be set aside in order to keep the sort of software, the system intact. There were dissenting arguments that said it doesn't make sense because there are lots of people who don't drive, whose face is simply not in the system. So there's a disagreement about whether or not this is a system that's really going to provide the security that the Alberta government, in this context with respect to driver's licenses, was providing. In my view, there are all sorts of reasons why people who have religious objections should be allowed to have exemptions. We have them in all sorts of venues. That's the point of human rights doctrine.
Just to repeat my first question, I'm not going to say anything again. What you're saying is that how many lives should be sacrificed? For example, if face recognition software cannot identify a potential bomber, as was the case, for example, in the tube bombing in London, how many lives are you willing to sacrifice for the right of a woman to hide her face?
I don't know.
I think the question is, how much freedom would we be willing to sacrifice to live in a society that might have greater security? How many police are we willing to pay for? Do we want the military on our streets so that we can have greater security? I think issues of living in a free society extend to the question of what those freedoms are. I prefer to live in the free and democratic society that we have, to disagree with the Supreme Court of Canada, to disagree with members of Parliament, to disagree with legislation, to see changes of government come and go, and to engage in a society where I don't always get my own way, but who does? And yet I have the freedom to walk down the street, I have the freedom to engage in conversation with just about anybody who's willing to converse with me, and I can have a reasonable measure of confidence that when I speak to a police officer in search of directions, that he or she is going to give it to me.
Thank you. Can I be able to say what the answer was beside the point?
We'll move to the front rank.
My name is Francis. My question would be to Honorable David Anderson. Is I see that the cop is mostly dressed in Canada in general, and also I see that in that religion freedom is given that the cop should have to be dressed in the public, or it has to be prevented in the public, because mostly a lot of people, they use the car to get whatever they want. Some robbing the banks, some sell the drugs, some do whatever. Even the guy can dress that in the car and nobody knows who he is or who she is. And I saw when I went to get my health card, I was checking the details in order to get my health card. And spoke of the card were online. Then we were checking, we don't know who are in the car. Is that the lawful for us in order to be save us what happened in London? And I believe that rest of the Haiti and Tunisian, Turkey, they prevented, and those are all Islamic states. So what is the role of Parliamentary like you? Is that are you guys sponsor that the cop should have to be working in public? Thank you.
My role is to moderate the debate tonight. And so I certainly heard some presentations that I think have challenged us tonight. I was reminded when Mr. Wallace was speaking earlier, when he was talking about the other, in what situation do we become the other? And when we see the rapid changes that have taken place in our own country, should we be paying attention to those who are now seen as the other? Because do we run the risk of finding ourselves in that situation at some point in the future? So, anyone that can respond to the question?
Mark Cuban was talking the other day about how he crosses the road if he sees somebody in a hoodie with the drawstrings pulled tight around his face trying to board him. And I think that's become more of a concern than someone in a niqab, partly because the hoodie shows up when it's going to show up. We've had issues with people wearing balaclavas to rob banks. Doesn't mean everyone who wears a balaclava is going to rob a bank. Some are just skiers. If we want to look at what's happening to our society and question issues of the outlier, I'm seriously concerned about what's happened with Trinity Western University's proposal for a law school. Because all of a sudden, a religious community that has made a proposal where they've demonstrated that they accept the other into their midst is being vilified by people who are supposed to be the defenders of our law and our Constitution and being turned into the outlier. Trinity Western University is one of dozens of universities, Christian universities, private Christian universities in our country. And where will they all stand at some point in time? It is too easy to identify the other, to create an outlier, and then to go after them. I'm not saying that our country has been innocent of that in the past. We have accepted and admitted our mistakes, and we're still trying to redress many of them. Faith communities have been guilty of that in the past and are in the same process of trying to redress. Gosh, folks, we have some great constitutional documents and great mechanisms in our country to work with. None of them are perfect, and as Winston Churchill said, democracy is the worst form of government except all the others.
So we've come to the end of our time. I'm wondering if anybody else now would like to or whatever. I want to thank everyone for coming out tonight. I think we've been challenged and learned a number of different things tonight from the four religious state models, religious state models that we've seen in Canada, state church, basically a separation of church and state, and a secular system. We've heard about three eras of religious freedom and persecution in our country. We've been challenged and informed about the impact of the charter as in Canada, and certainly we have been very challenged with a case study that I think has pointed out to all of us that maybe some people need to take a look at in our own thinking. And I think the one thing that I really got from you is comfort and effective measure of religious interaction. Our comfort and effective measure of that. And that's a good thing for us to check. In 2011, when we started this, it's interesting because there wasn't a lot of interest in this town on religious freedom issues. We did the first forum. There was no particular interest amongst any of the parties or whatever. We just decided there was a bit of a gap there and we could try to fill it. And then in 2011, of course, part of our campaign was to put the Office of Religious Freedom into place. And since then, it's been interesting to watch the growth of interest in this topic. And it's been led by some of the people in this group for many years. But we see now some changes in our society, some of our provinces, and some of the law societies are the ones who have amazed me because they're the ones who supposedly stand for tolerance at all occasions, and we're seeing bitter intolerance, I would say, coming from some of them. So we've seen some changes, but we certainly have interest in this issue. And so I want to thank our guests for coming out tonight, reminding us to just ask ourselves how we're doing in this country. Take a look at our history, and take a look at where we're at now, and that challenges us then also to move forward to where we're going in the future. And so just to close, I would like to give our guests a small token of our appreciation and